I guess we'll have like an informal recording. Hello, everyone. My name is Ken Vercammen. For the people at the Senior Center, I had to bring a business card. Now, also, sometimes people they would say, "I can't hear you." It goes, "That's because you're sitting in the back row. Move closer." My dad's 91, and sometimes I'll go, "Turn down the TV. I can hear it from up here, and you live in Jackson. Turn the TV down." Okay, so number one, when I first came in, I was talking to someone about what bad things happen if someone doesn't have a will and they pass away. Well, the process becomes much, much more expensive, much, much more difficult. If your goal is to make it more difficult for your family, don't listen to anything that I have to say and just wing it. It's kind of like, yeah, I know that there's a leak in the basement, but I'm going to ignore it because that's going to be my kid's problem down the road. So, if someone doesn't have a will, or the will wasn't signed correctly because it was some cheap thing online, number one, all of the beneficiaries have to agree upon who's going to be the administrator. They have to sign renunciation in front of a notary and pay the fee to have a file with the surrogate. And that's in states where everyone gets along. A lot of times people don't get along. Okay, what has to happen? Well, that means that someone got to spend a ton of money having what's called a complaint order show cause filed in the Superior Court asking that they or someone become the administrator. And even with that, sometimes the judge will say, "You know what? These people all don't like each other. I'm gonna pick someone on the outside, and then they'll charge more money." Okay. Now, also, if there's no will or it wasn't signed right, there has to be a thing called the surety bond taken out by the administrator. That costs another $1,000. So, state law determines who gets your assets, not you. More and more people are not giving their assets to their kids or their family. It's your right to do with your stuff what you want. If you want to leave everything to the Yellow Dog Society, I joke that if I would have had the yellow lab first, I don't know if I would have had kids because the dog is always happy to see me, and always running up. The kids a little less. So you want to decide who gets your stuff, not the government. If someone has minor children, I'd say a stranger at the courthouse determines who gets custody of children. So sometimes for the people, you have grown kids, sometimes you have grandkids that just had their first baby. Well, it's a good idea, even if someone doesn't have money assets, who would be if both parents are gone, who would be the guardian? And so the whole thing is, and also if there's no spouse, children, or close family, the government, the state of New Jersey gets the money. Okay, who in this room would want the state of New Jersey to get everything you work for? Zero. So it's kind of like, when loved ones are grieving, you shouldn't give them one more thing that they have to worry and deal with. So think about, who do you want to get your assets? Who don't you want to get your assets? Sometimes and you also don't want 18-year-old grandchildren to get money outright, because how many 18-year-olds will do anything smart with money? Zero. I mean, I went to high school up the street in North Edison. Boy, if I would have got a chunk of money when I turned 19 or 20, I would have went to Maloof and bought a red fast car and not worked as hard. So the surrogate also reminds people when they did seminars with us, beware of online forms and documents because they see that's where the problems come in, where people, they use the word cheap out and try to do stuff, and then it's not signed right or not done right. So, and make sure that if you have a will, it's what's called the self-proving will. So, what's a self-proving will? Under the old law, that the person signs and two witnesses sign, but then one of the two witnesses had to go to the surrogate's office and sign a affidavit saying that they were a witness. The law was changed for what's called the self-proving will. wills that were done a while back might not have been self-proving. I know there was a law office in Carteret that intentionally did do self-proving wills, so the people used to have to come back to them, you know, after a family member died. So, now, let's see. We learned a lot of things through COVID. We learned that we could do stuff through the computer, through email, and that new thing that they just invented called the telephone. You know, people says, I'd like to set up a Zoom conference with you. What, you need to see me? I'll tell you, I look like this and I'm wearing a suit, but I would. So we made it easier for most people. We would email a questionnaire. I'd say, and it asks, like the one from my Oaks Club people, it's 1 page long now. I'd say, because I know that they don't have any minor children. Okay, what's your name? Do you have a spouse? Who's going to be executor number 1? Usually a spouse. Who's executor 2? Who gets your stuff? Not that complicated. Let's see. Why put stuff off? So, logistically now, what a lot of attorneys will do is you can type, they'll email you the questionnaire. You can type it up. Some of the seniors say, I'm not very good with computers. Hey, no problem. Do you have a child or a grandkid that's in their teens that lives not that far away? Yes. Okay, well, why don't you tell your granddaughter, hey, listen, I want you to come over for about 30 minutes, help me out with something. I'm going to give you $5,000 to do it. And that granddaughter says, oh, you know, I'm really too busy to see you in the next 3 weeks for 30 minutes, and they live a town or two over. Hey, no problem. I'll give the money to someone else. You told me you don't need it. You know, and again, I did a will for, I redid a will for one of our past clients. He calls me up and he goes, Kenny, I got to redo the will. I was leaving everything to my grandkids. I haven't seen them in 2 years, and they didn't even come to their grandmother's funeral. Okay, you know, fine. Now, importantly though, I'd say did the new will. Unfortunately, he never changed who the beneficiaries were on his accounts. So these kids that never visited their grandfather got some of the funds. So Brandon might touch upon that. It's important. A will does not change who gets your assets if you pass away, if they go directly to that person. So you have to change it. So if you have an account with Merrill or some other company, and you have someone as the beneficiary, they get it outright. Let's see, if your will says everything's going to the Yellow Dog Society, but your account has some nephew that you haven't seen in like 2 years, that person that you haven't seen in 2 years gets it. So, let's see. Now, who should be the executor? Let's see. Most people make it a spouse or a kid. Some people have someone on the outside that because, our rule of thumb on the executor is, can they drive to a bank and walk up a flight of steps? It's not that we're old or disabled. We've got to be practical because there's stuff to do, and a lot of the stuff cannot be 100% done online. Let's say occasionally someone says, like, if they don't have children in the U.S., they'll ask the attorney, goes, listen, let's say, will you do it because my kids don't live around here, or one person, well, my one kid's in jail, so I don't think I could trust him. Okay. You still want him to get stuff? Yeah, that's a good idea. Instead of giving it to that son, let me give it to his kids instead. So, you have an executor 1 and executor 2. You don't want to have joint executors. It creates more work. Why make more work? You could have twins living together, but that means they both got to sign every check, do everything. It's better to have a number 1 and a number 2, not joint. And those are for what people get along. Sometimes people don't get along. I had we were involved. I had to go to court because these 2 brothers couldn't agree upon what color the sky was. Brother number 1 says the sky's blue. The other one says, no, it's gray. You're stupid. You've always been stupid. I specifically remember the judge saying, fellas, we got to take a break. Why don't you guys go downstairs and have a cup of coffee and talk about fun stuff? You guys just spend all this money on court costs and fees, etc. So, now, we've touched upon certain assets don't pass under the will. So, if a house is owned husband and wife, automatically goes to the survivor. Let's see. Sometimes, if one of the spouses is very sick, and we think that they might have to go into care facility, sometimes it's a good idea to take it out of the joint names and just have it in the what we call the well person or the community spouse's name, because otherwise, if the community spouse passes first, it goes to the person that then had to go into the nursing home. Then the nursing home gets 100%. So other assets that pass directly. Wherever there's a beneficiary. So, if there's bank accounts, if they're joint accounts, payable upon death, joint tenancy, automatically goes to the survivor. The will can't change that. All right. So those pass by title. Other assets pass by contract. So you think of IRA, 401k, life insurance. Who's ever the beneficiary. And also, it's if someone has minor children, I tell them, don't make the life insurance person will automatically put the minors down as the number 2. I goes, no, you want it just to be your estate, because otherwise, the day those minors turn 18, they get the money. And again, let's see, which one of you people in the room would have did smart things with money at age 18? Come on, raise your hand. She would.
I'd save since I'm really young. We used to have.
I would. I went to the memo when I got my paycheck from Roy Rogers. I would cash it, the same bank that I had my paper route, and then I'd go over to Malmo Mall and go to the record store. And then Monday, I goes, "What happened to all my money?" "Oh yeah, I bought all these records." Funny thing, I still have most of them. Yeah. So, all right, so. Let's see, we have, let's see, believe it or not, New Jersey did away with some of the taxes. So there's no inheritance tax if it's going to spouse, children, grandchildren, stepchildren. There is a federal state tax, but it only applies to those people that live across from the Colonial Country Club that have $13 million or more. Otherwise, there's no. Now, it could be, the federal government could change that. And when, 10 years ago, the tax started at $6,775. That wasn't a lot. I mean, that's the value of a lot of the houses now. Right? Again, right now it's $13 million. We'll have to see what happens after the election. Okay? Now, you always want to have a clause in a will that says if anyone is under 21, either the executor or their parent holds the money, it can be used for health, education, maintenance. When there's minor children, we usually have a clause to protect them because their parents aren't around and they might be very young. They get some when they're 22, some when they're 25, the balance when they're 30. But as much money as is needed can be used for health, education, maintenance, college, grad school, etc. My son was smarter than his father. He went to University of Miami. Everyone thought that was a party school. Well, every school parties. I mean, they party at rabbi school, but it's now. I think the tuition is $90,000 a year. So because it's a private school. So, some people say, more and more people nowadays are saying, you know what? My own children already have a house. And they haven't put away money for my grandkids. Instead, I'm gonna have it go to my grandkids. That way, it can be used for health education. Now, by the way, if anyone has any questions, you can raise your hand. You can raise your hand. Okay. Because Mrs. Vercammen, my wife, says you can't be hanging out for hours because I'm going to have the dog in the car and I don't want to be here. Okay. First question. Yes, sir.
You mentioned that it costs more money if somebody does not have a will. What kind of a cost is involved?
I usually say, well, if everyone gets along, it's probably gonna cost between the bond and the administration, maybe $2,000. If they fight, then they're looking at a complaint order show cause, where going to the court, usually, the rule of thumb is it might cost like $4,000, because not only what has to happen is there has to be this complaint to Superior Court, then everyone on the planet who is entitled to inherit has to be served with the notice of probate. And then then they all want to come to court, they want to fight, oh, I want to be the administrator, and becomes much more of a project. So, because why would you want to, it's kind of like, having a will done might cost you about $500, and that's an investment, someone says, I'm not going to do anything. Don't be a Carl. Carl was as well off dying in Edison. And he came to our office in Edison to see us, and but he was a retired engineer. You know how some of these engineers are, where they read, they read the whole manual on the car they get, the whole manual on the computer they got. Carl, oh, I want to read more up on this. Carl, you don't need to read anything. I went to law school, I passed the bar, I go to seminars, I wrote a book on this. You don't need to read anything. I want to read more. Okay, fine. That's it. 2 years later, Carl's daughter calls. Do I have his will because he passed away? No. He kept on wanting to read stuff and never paid the money to get it done. Don't be a Carl. Okay, you had a question, man. All right, who?
Yeah, instead of listing beneficiaries on policies or whatever you have, can you have it state to go to the estate of?
You can have, on your policies, you can have it to go to the estate of, but I usually don't recommend that because only when they're minors, or you think that they're just going to blow the money. Okay? If they're adults, Brandon, just put them as beneficiaries, because then two things: the money doesn't have to go through the probate process. Number two, the executor isn't able to take a commission on money that doesn't go through the estate. Oh, are you with me? Okay. If there's a $1 million estate, but $950,000 worth is in a brokerage account and it has direct beneficiaries, the only amount that the executor is dealing with is that 50. And it's very common where, husband passes, the daughter and the wife come in, and about probate the will. Sometimes I head them off ahead of time. I'll call them up. I'll go, okay, the house was in joint names, right? Yes. And all the accounts were either joint or payable to you, correct? Yes. Aside from, his belt and his army clothes, he didn't own anything, right? Kinda. Yeah, so I said to him, I just saved the $180 and going to the surrogate's office because you don't need to probate the will. But then, sometimes when we talk, we make changes, because oftentimes we'll update wills as things go on, because the person was picked as the executor either passed away, moved out of the area, or isn't able to do it. All right. Now. Oh yes, ma'am.
You do not have any assets other than everything that is joint. You do not need a will, do you?
You still need to have a will if everything is joint, because what happens when both go? Both aren't going to live forever. So, your will could still say everything to my spouse. Afterwards, who gets it? Now, let me talk about, oh, yes, ma'am.
What does the executor do? Do they get paid?
The question is, does the executor get paid? The executor gets paid if they want to get paid. All right. So, there's a thing in New Jersey called an executor's commission. And it's 5% on the first $200,000, 10 grand. After that, it's 3.5% on the amount up to $1 million. But that's only if they want to take it. Most estates, the executor says, listen, it's all going to my brothers and sisters and my family. It's not that complicated. I don't feel good about taking more money. Now, on the other hand, sometimes some of the beneficiaries really give the executor a hard time or aren't cooperating at the end. So we usually say, listen, at the end of the estate, if everyone signs the form that they approve of the informal accounting, the bookkeeping, and they sign the release and refunding bond, the executor will not take a commission. However, if anyone won't do this within 3-4 weeks, sign it in front of the notary and send it in, then I am going to take the commission, because now you're giving me a hard time and making me work hard. I also tell the executives, I was talking to someone last week, I goes, by the way, hire people. I go, you work full time, or even if you're retired, you don't want another job. Don't do the dirty work of cleaning. Oh, I got to clean the house. Hire people to do that. I'd say, your job is to kind of do the smarts on figuring out the accounts or stuff like that. All right. Let's talk fast about specific bequests. A specific bequest, some people leave a specific amount of money to grandkids, a specific amount to their church, their high school, their grammar school, their college, charities that they like. Now, I'm in favor of leaving something to a charity, but you're better off putting a set amount, because if you're foolish enough to say, oh, and I want to give 1% to this charity, that's going to delay the whole estate by at least 13 months, because that means that the Attorney General's office has to review the accounting, approve it, and it drags it out longer. I'm involved with an estate where these different charities we're getting like a half of 1%. It's like one was like you. There's also some of the men have firearms. They wanted to go to someone that has a firearms ID. Whatever. On the other hand, we have also what I call the reverse specific bequest. I leave nothing to whomever. You don't leave them $1, you don't put a reason, nothing to that. Because basically, come on, they know why they weren't put in for. I'd say, someone goes, can someone contest the will? Listen, anyone who could have inherited can spend a lot of money on legal fees to try to contest it. But the but part is, they're probably not going to win. I'd say, this lady was challenging the will and what was done. And so I have her on the witness stand because I represent one of the good sons. Okay, ma'am. Okay, in 2019, let's see. How many times did you visit your father? We had none. Okay. How many times did you call him? Okay. How many times did you send him a card or do anything? And so I'm doing this by each year. Finally, the judge goes, okay, Mr. Vercammen, I can kind of get your point here. Now, on the other hand, this one man calls us up and he goes, I want to challenge the will. Okay, the judge is going to ask you, okay, how many times did you visit your dad in the past 3 years? We had a falling out. Okay. How many times did you call him up to say, listen, I'm sorry we had a falling out. Why don't we go get a cup of coffee and beer? I didn't do that. Okay. How many times did you send him a letter or a card saying, I'm sorry we had this falling out. Why don't we say, none. Don't wait. Hey, don't waste your money. Yeah. So, the will is signed in front of an attorney or notary with 2 witnesses. the person keeps the original. They're not filed with anyone. If there's minor children, there's guardians for the kids, and you put down people to be trustees. I mentioned make sure you have a self-proving will. Some people have, sometimes there's kids with that are receiving, have special needs, SSI, SDD. Don't leave money to them outright; they will lose their entitlements. Okay, once you sign your will, that's your property. The attorneys no longer keep it. Put it in a fireproof box. If you have access to a scanner, scan it, email it to yourself though. Executive 1, Executive 2. Make sure that they know where it is and how they can get to it. Don't put it in the bank. Why not? The bank safe fund. Because you can't get to it.
Thanks.
Just like a lot of times, like you need all of a sudden you need the living will of power of attorney on a weekend. You can't call up Wells Fargo's. Hey, can you do me a favor? Have someone drive over there on Sunday afternoon. And what happened 4 years ago in 2020? Couldn't get into banks were closed. So okay, that part covers wills. Hey Brandon, can I put you to work on that? The office charges a consult fee, but if someone contacts us in the next 30 days, then we don't charge the consult fee. Let's talk about, I already mentioned, don't be a Carl, you don't need to read something. Yes, ma'am?
What is a self-proving will?
What is a self-proving will? There was a change in the law, so the person's signing twice, both witnesses are signing twice, there's some language to conform to the statute, and then the attorney or notary signs twice.
What if you have a will already that only has one witness?
It is not a self-proving will, and the executor would have to locate one of the witnesses. And if they're dead or gone, that becomes a problem. So if it's that old, get a new one.
If you want to change the executive.
If you want to change the executor, it's a paper called, we call it a consult.
I have to go to a lawyer, or
Well,
I just
here's the problem. The question is, do I have to go to a lawyer? I goes, the surrogate says when the people try to do stuff themselves, it's like trying to do your own electric work yourself. If you do it right, that's good. If you do it wrong, it's not good. My wife watches YouTube videos on how to do stuff. Oh, I can do it in plumbing work. If you do it right, oh, you save money. If you do it wrong, you still need the plumber. Real fast, my first house, I was very proud because remember we all had landlines, and I was able to make a phone line and run the cords to all the rooms. And so I bought a second house, and it was an older Cape Cod, and had 2-prong outlets, not the good 3-prong outlets. So I go, oh, I can figure out how to do that. I go and I buy the kit. I'm changing it from a 2-prong to a 3-prong, and we turn the power off. And I put the wires together. Then I yell to my wife, "Okay, turn the power back on." No, there's spokes and there's sparks, smoke everywhere. I go, "What? Turn the power off." It looks like we got to hire the electrician. Okay, somebody else has a question on wills? Yeah.
Do lawyers now automatically do self-proving wills, or do you have to ask?
Here's the funny. You got to ask, because some of the offices are very small, and if someone just works by themselves, I knew a guy that I told you in Carteret, he didn't do self-proving wills because he was hoping to get the estate down the road. They're in the back.
Yeah. Can the will stand if you leave the state?
Oh, the question is a will still good if you move to another state? The answer is yes. A will that is done in any state is valid in any other state. However, there's a difference between being valid and what is best for you. Okay? Let me now quickly talk about trust, and I will get back to you later, because I only got so much time. Okay. My mother-in-law used to call me up every other year. I want to come in and get a trust done. And I would say, were you watching Susie Orman on TV? And she goes, yes. Okay, Susie Orman is exactly right if you live in New York, California, Florida, where probate is very complicated, very expensive. Takes 3 years, costs $15,000, and everyone's, aggravated pulling their hair out. New Jersey, I ask people, why do you think you need to do a $5,000-$6,000 trust when a $500 will would handle what you really need? And I always say, I love making, I tell people, why I need to spend all this money? I love making money, but sometimes it's like, when I was on a trip and I was reading this book that I bought, it was called Marketing, Building the $1 Million Estate Practice. But it was really about trying to trick people into having trust that they didn't need. I'd say, a revocable trust does not cut down on taxes. Our revocable trust does not protect assets from nursing home. The only thing it does is save you from having to go to the surrogate's office and pay that $180 and give them the original will and original death certificate. Let's see. Other states, though, that's why I always say, depends where someone's at. I only practice law in New Jersey now. I was originally licensed in New York. I passed the bar when JFK Jr. failed for the second time. But he was dating Daryl Hannah, the actress, so I think if I was dating Daryl Hannah back in the 1980s, I probably would have failed the bar too. If you buy or inherit property in Florida, you definitely want to have it owned by a trust because Florida is so complicated. Same thing with California. Now, other people have what's called, people sometimes say, okay, I want to protect my assets in the event I have to go into a nursing home. Well, that's called an irrevocable trust. The attorneys that do it, well, they're going to charge someone $12,000, $13,000. And it goes, that's a lot of money. Well, if you're that concerned, that's what 1 month cost of nursing home would be. So, you're making an investment. Let's see. When people ask me, and on the other hand, it's better to, if someone's that concerned about protecting assets for nursing home, you're better off spending the money on the trust than just giving your assets all to your kids right away. And why is that? Well, we handled an estate where the man didn't want to spend money on the nursing home Medicaid trust. He goes, I'm going to give half of all my money to my son, half to my daughter. I'm having a deed done on the house, quick claim deed, half to my son, half to my daughter. Boom, I'm done. Then the son dies. Well, who now owns half of everything that he ever worked for? His daughter-in-law and ex-daughter-in-law. So that's who owns. So, it's something to think about now. People have asked me, a lot of times it's the kids. Oh, mom or dad wants to protect their assets. I said to one of them, they're very concerned. And they go, why do you buy long-term care insurance? Oh, it's very expensive. Well, you just said you want to protect help them. Well, I don't spend any money. Then they asked me, hey, what would I do or what did I do? I goes, I'm not transferring my assets out of my name. Let's say, so that basically you have to be penniless. And when you're penniless, you don't get, there's nicer nursing homes and then there's smelly, dirty ones. Do I want to be in the smelly, dirty one so my son, Dr. Brendan, the dentist, can have a bigger boat? No. When I was a paper boy, bicycling in January in the rain to deliver papers, making like 10 cents a week, for each house, it wasn't so that my kids could get a windfall. I mean, that's just me. I mentioned if someone contacts us in the next 30 days and fills out the form, they get a free copy. And some people, by the way, some of the people working for big companies, and the Lakefront is one, they have as an employee benefit legal plans that pay for doing documents, common name, biggest legal plans in New Jersey are MetLife, ARAG, and Legalese. All right, now we're going to talk about power of attorney because I only got 5 more minutes. Okay, a power of attorney, a will takes care of your assets if you pass away. See, a power of attorney is while you are alive, but you're giving the power to someone that you trust to be able to work on your behalf and do stuff for you. All right? Sometimes it's the spouse, but again, can the spouse get around and do stuff? If they can't, you make it, you make it one of the kids. Some people have no one in New Jersey or no one in the U.S. They find someone that they trust. See, the power of attorney is either effective right away or only upon disability. When it's effective, we usually recommend when it's like, it's a spouse or kid. Make it effective right away. Don't make it more complicated where it's only effective upon disability, because the bank or financial institution is going to give people a hard time on what to do. Let's see. When it's effective right away, it's called the durable power of attorney. And when it's only effective upon disability, it's called the springy power of attorney. Fred, one of our clients, he goes, Kenny, I'm a carpenter. I don't understand legal stuff. Explain to me in carpenter language what that means. Okay, Fred, you put your son down on your power of attorney. If it's effective right away, your son can steal all your money and go to Cuba and live in a nice place on the beach. If it's effective only upon disability, he needs to get a note from a doctor before he steals all your money and goes to Cuba and lives on the beach. Knowing that you trust your son. He goes, I trust my son with my life. Okay, good. Make it effective right away. I picked Cuba because that's they have no extradition with the U.S. So if you, and no one said, man, I want to go and hide in Russia or some cold place. You don't say, oh, I'm going to steal my family's money and go to Uzbekistan. I'm going to steal the money and go to Iceland. Oh, I'm told Iceland is warm. Greenland is the cold one. Now, interestingly, those are different changes in the law and powers of attorney. Some of the banks would give people a hard time. Wells Fargo, it wasn't done in our form. So New Jersey legislature came down with a statute that says, listen, if it makes reference to New Jersey statute, they're supposed to honor. But it has to make reference to the statute. Section 2 of PL 1991, C95, C 46.2B-11. And I'm pretty sure those free things online or cheap things don't happen. We revised our document, our powers of attorney. We include a HIPAA authorization, a post authorization, designated caregiver, different statutes that have been passed in the past couple of years. Now, I mentioned a will is good forever, but a power of attorney, there's no statute that says how long it's good for. So we usually recommend that a new one be re-signed every 5 years. If you move to another state, have another one done, because if you move to Pennsylvania, Delaware, Florida, they might say, what's this? We don't know about this New Jersey stuff. Okay. You had a question?
Yeah. The power of attorney, is it for both medical and financial?
No, the one that's on medical, I would call the living will advance directive. All right. Question in the back, sir.
If you want to give it in terms before that, how do you do that?
I'd say you take out your checkbook and you write a check and goes, here you go. If it's more than, I think, $15,000, you got to get the accountant to fill out a form to be filed with the IRS, because you're only allowed to get, I think it's 15 grand this year, without having to pay a gift tax. But you're able to use a portion of your $13 million federal estate and gift tax. So
there's no gift tax?
So there's a lifetime gift exemption that you can use.
You can gift up to $13 million, but you have to fill out
You just have to-
this tax form.
I don't know those kind of problems.
But if you give more than 15 million, for example, if you say, listen, my grandson's parents aren't well off, I'm going to pay his tuition for this semester is $22,000, that's a gift, technically, the accountant got to fill out the form for you. Use an accountant for that, by the way, not the attorney. Different people occur. Now, you had a question, someone else had a question on wills before I jumped off. We'll be around for 5 minutes and 1 second after the program's over. Okay. That's okay. Now, the last document I am going to talk about is the Living Will Advance Directive. Your will takes care of your assets if you pass away. Your power of attorney, you're giving the power and so on. What the Living Will Advance Directive is someone's in a coma, irreversible condition. I'd say you can no longer talk. You're giving instructions to family hospitals and doctors, basically saying what you want. I'd say, and so the document really isn't for you. It's for your family, so they don't have to suffer with having to make those kind of decisions, because you've already made it for them. Some years ago, a little old lady, she didn't want to do the living will. She had the will, she had the power of attorney. Because she didn't have family in New Jersey, I was her power of attorney. Hospital calls one day. Okay, listen, she's in the hospital, she's non-responsive, go there and the doctor's there. Should we remove life support? I'm like, geez, I feel bad. What the right decision is on someone who's 92 years old. It's not going to open up their eyes or get up, but yeah, I couldn't even do it for my dog when my first dog was so sick. So the idea is that you put it down and you have a clause that says, listen, if I'm in a terminal medical condition, I can no longer talk, I'm in a coma, it's the doctor says it's the last week, whatever. Okay. I don't want to have fluids and nutrition provided. Next directive has the medical treatment. No artificial means at all. Years ago, people were afraid to say, does that mean that they're not going to resuscitate me if I have a heart attack? No, it's really when the doctors already found that the person is, in an irreversible condition. So, if you're buying grapes over at ShopRite and you have a medical problem, they're going to do what they can to keep you alive and bring you over to the hospital. We've revised our form of the Living Will Advance Directive to have a medical records or access under HIPAA, and similar to the will, you have a number one person to be contacted and a number two, and it's also important because sometimes in the family, people have differing of what should be done. Well, once you pick one person, they're the captain of the ship. And we found a lot of times in families that there was someone that was the most helpful one, and then another one that was not helpful and never around. But then when mom or dad is in the hospital in the last days, all of a sudden they come marching into the hospital room and go, okay, I'm in charge now. This is what we're going to do. No, you're not in charge of anything. You're lucky we even let you into the room. These documents are very, very important, not just for married people with kids. It's for people who aren't married with kids. We've done a lot of documents for people that are unmarried and gay lesbian couples that aren't married, because technically they don't have any legal right to be in the room. And there are times where the parent that didn't approve of the relationship would come in and goes, okay, you got to leave now. Well, this is my partner. Well, no, you're a friend, get out, you have no legal rights. So it's important to have these documents. So the power of attorney, scan it or make copies. Make sure number one has a copy, number two, or email it, and your financial advisor and your accountant. Next, the living will. copy it or scan it's better. Email it to yourself, to number 1, number 2, and your primary doctor, so they have it. And the last thing in my last 20 seconds I have, because I went over. Not a legal document, but something that you should do. It's called a letter of instruction. I kind of have a form that people can fill out, but it's not a legal document. The will doesn't list any assets, but in your letter of instruction, you can provide it to your executor 1, executor 2, kind of either emailed it or in a sealed envelope. This is what I have. This is who my contacts are. And nowadays, these are my passwords for my accounts. And sometimes, and there's, by the way, there's no other things other than these accounts. It's very difficult sometimes, you know, family contacts me, you know, like my brother died, he has no kids. We don't have a clue. We know he owned this house, but we don't know what he had because he did everything online and didn't do any planning. So, in a nutshell, kind of don't screw your family, make it easier for them. If you don't want them to get stuff and you're going to leave it to the dogs or wherever, make it easy for the dogs. And so now, when you leave, you can leave those forms out there. And now Brandon's going to come up and tell you some smart things about